committee, we have Professor Andrea Borkman. She's a professor at the University of California Davis School of Law. She's currently a visiting professor, guest of the P. Fortier International Arbitration and International Commercial Law seat at McGill University in Montreal. Professor Bjorklund has specialized in international economic law, international arbitration and litigation, international trade. Before starting at Davis, she was the Bigelow Fellow in Lecture in Law at the University of Chicago, and she was then the attorney advisor in the Office of the Legal Advisor for the United States State Department, where she defended the United States as a respondent in investor-state arbitrations that were brought under Chapter 11 of NAFTA, the North American Free Trade Agreement. She was also senior counsel to Commissioner Thelma Askey of the U.S. International Trade Commission. She has written extensively in this area of international dispute settlement, investor-state arbitration. She is the co-author of a book known as The Investment Disputes Under NAFTA, an Annotated Guide to NAFTA, Chapter 11. To her right, we have Doug Bishop, who is the head of King & Spalding's International Arbitration Practice Group. Mr. Bishop has over 25 years of experience focusing as a practicing lawyer in international arbitration and litigation involving a diverse array of matters. Virtually anything that you can think of or that we could put in an FDI Moot problem has probably been something that he's worked on and handled in one of the cases that he's had. He has developed an international reputation for his experience in international dispute settlement and serving both as arbitrator and counsel in many different cases. He presently serves as chairman of the executive committee of the Institute of Transnational Arbitration. He's a member of the U.S. delegation to the NAFTA Advisory Committee. He has served as chairman of the litigation section of the State Bar of Texas and co-chair of the American Bar Association for International Litigation. Like Professor Borkman, he is also an author and has written extensively in this area, certainly one of my favorite books for this area, Foreign Investment Disputes, Cases, Materials, along with Professor Reisman and Professor James Crawford. And as you'll find out later, there's a new book that he's been working on, which happens to cover the topic of annulment. Thank you very much, Mr. Bishop. And then finally, to the left of the chairperson, we have Professor William, or Rusty Park. He's a professor at Boston University Law School here in Boston. His practice and teaching over the years has focused on international financial transactions and, of course, international arbitration. He has served as the director of Boston University's Center for Banking Studies. He's held academic appointments at many universities around the world, including Cambridge, Dijon, Hong Kong, Auckland, Geneva, the Fletcher School here in Boston. He served as arbitrator under virtually every set of international commercial arbitration rules you can think of: AAA, ICC, ICSID, LCIA, UNCITRAL, and ad hoc proceedings. In 2008, the United States appointed Professor Park to the panel of arbitrators for the ICSID Center, the International Center for Settlement of Investment Disputes, and in 2010, he was appointed as president of the London Court of International Arbitration. He is also a very active author, and one, I would say, of the leaders going back to the publication of Arbitration of International Business Disputes, which is published by the ICC, and since then has certainly published many, many other authorities, articles, and is prolific. And so we have, as I would think, a fairly well-qualified final panel to hear the case here today. And so I'll turn it over to the panel and the secretary.
Thank you. Welcome, everybody. Can you tell us how you're dividing your time?
Claimant will begin, and I will speak for 19 minutes regarding issue 95, and my co-counsel will speak regarding the issues 2, 3, and 4, and then respondent will also use.
Okay. Thank you very much. Well, welcome everybody. It's a pleasure to see you all here. It's been a delight. I've been here now for 3 days. It's been a delight to see all of you competitors and to see the time and the effort and the work you've put in. And it's a real honor to be here at the finals, and we look forward to hearing from you. And claimants, when you're ready, you may begin.
Good afternoon, Madam President, members of the Annulment Committee. My name is Christine Arcari, and this is my co-counsel David Wall. As I mentioned earlier, I will be 18 minutes to address the two first issues. So first, I will demonstrate that by confirming Dr. Irakunda's nomination, the tribunal was not properly constituted. And second, I will explain how this tribunal is departed from several fundamental rules of procedure. And next, my co-counsel will also take 18 minutes to make respondents, three following submissions, and reserve 2 minutes for rebuttal. Turning to claimant's first submission, the Annulment Committee has the power, through Article 52(1)A of the Exit Convention, to admit the award, to annul the award if the tribunal is not properly constituted. The Exit Convention did not define the terms properly constituted. However, the grounds under Exit, Article 52(1)A, goes to the very heart of an Annulment Committee's rule, which is to protect the integrity of the Exit system. The Annulment Committee in Sukaki versus United Arab Emirates explained that the object and purpose of an Annulment Committee or the annulment mechanism is to safeguard both the integrity and the legitimacy of the exit process.
And why should we, excuse me, counsel, but why should we be persuaded by what the Soufraki Tribunal said? What authority does that have for us?
There is no stare decisis in the exit proceedings. However, the idea that an annulment committee is there to safeguard the process is what Article 52 stands for. There are very limited grounds under which this annulment committee is permitted to annul an award. And what claims is submitted is that 42(1)A of the grounds do allow this committee to review whether or not the tribunal is properly constituted, and consequently look at the independence of Dr. Irkunda.
Is it your submission that Article 42(1)A in conjunction with 52 permits us to review the decision on challenge made against Professor Irkunda?
It is our submission that Article 42(1)A does allow it, yes.
So you think we can revisit the initial challenge submission?
We believe that because it goes to the integrity of the process, this is a possibility for the annulment committee to do. However, if in the event this committee does not feel comfortable to review matters that have already been seen by the previous tribunal, there is new evidence that has come to light, and this committee should certainly look at that when looking at whether or not the tribunal is properly constituted.
How does this go to the integrity of the process?
How does independence and impartiality go to the integrity of the process?
Well, I think I understand those terms, but your challenge, how do you see this challenge in particular as involving the very integrity of the system?
Well, the result of having an award rendered by an arbitrator who lacks the qualities of being independent and impartial will clearly undermine the integrity of the system. If annulment committees were not allowed to look at this challenge decision, this would make the annulment process mechanism meaningless. And so that is why claimant is submitting that under 52(1)A, you should look to Dr. Ms. impartiality.
But the claimant has already had an opportunity to have a review. The two other arbitrators who were not challenged have already reviewed and made the decision on this. So haven't you already gotten the decision? You may not have liked the decision, but hasn't the integrity of the process already been protected?
Yes, in part, but not for the new evidence that has come to light once the award was rendered. And so to examine this new evidence, claimant submits that this annulment committee should look and use the reasonable doubt standard to look for this new evidence and to look at the new evidence. In many cases,
Where does the reasonable doubt standard come from? We're not in a U.S. criminal proceeding.
yes, under exit, it says that if an arbitrator manifestly lacks any of the qualities. However, the exit convention does not define the term manifest.
But it doesn't call it reasonable doubt, does it?
It doesn't. However, claimant submits that this is the standard that should be and I'll explain why. There's two main reasons. Although not binding, this committee should find that the IBA guidelines on the conflict of interest in international arbitration is persuasive. The IBA Working Committee found that the guidelines could be applied to investor-state arbitration. And furthermore, various ICSID challenge decisions, including ICS inspection versus Argentina and Alpha versus Ukraine, have used or looked to the IBA guidelines, even when the parties hadn't necessarily agreed that they would be binding. And so they look to these guidelines as to measure or not the impartiality.
And what aspect of those guidelines do you rely upon? What is the test under those guidelines that you rely
Reasonable debt, justifiable debts.
upon? Justifiable debts.
Exactly, which is comparable or very similar to reasonable debts. And the second reason we should use the standard is even the Institutional model law uses the reasonable debts threshold to disqualify an arbitrator. And now, for ICSID arbitration, it should not be more difficult to remove conflicted arbitrators. Not only is there the same desire that justice be seen to be done as well as actually being done, but there's an added element of public interest because they're not two parties that represent investors. There's one party that represents the state. And so this is why claimants submit that the reasonable debt standard should be used. And now,
But what about the term manifest within the ICSID convention? What do we do with that term? That is, how can we get to the IBA guidelines when you have a different standard seemingly put into the ICSID convention with this term manifest?
as I mentioned earlier, manifest is not defined in the ICSID convention.
It doesn't need to be defined. I mean, we can look at the Oxford English Dictionary to define manifest.
Well, there have been two different interpretations of manifest, and this committee, this committee submits that it should be reasonable debts. And in the event that this committee chooses to see the standard as real danger, the following new evidence does meet the real danger test as well. This annulment committee should employ wilderness's actions prove that they are clearly adverse to claimant's interests. They convinced Dr. Rancourt, a witness, that claimant wanted to cross-examine, not to participate in the arbitration on the very morning of his scheduled hearing. So this annulment committee should apply the same principle used by England's highest court of appeal in Pinochet, that a man may not be a judge in his own cause. A principle that court found...
But Wilderness isn't a party in this case. How would anybody be being a judge in his own cause?
They're not a party in the case. However, they did influence one of the experts that claimant did want to cross-examine.
Right, but we're not talking about the expert now. We're talking about the arbitrator Iracunda, no?
Yes, however, if we see that Wilderness had all of this influence and was able to influence an expert, then we must re-examine, or this did confirm claimant's fears that Wilderness did influence Iracunda as well.
But don't the uncontested facts suggest that all Iracunda has done is give, a nominal membership fee? She sent it for years to Wilderness, but she's not. It's the same way that one of us might belong to the Sierra Club without having a clue what they're doing.
Yes, she is a member who's given regular financial donations.
And there's no suggestion she's done anything more.
Well, she's also a member who fully supports their conservation principles which in fact push them to protest against claimant's treatment of the frogs. They've therefore chosen a side in the dispute, and that is what is the problem. Turning to the second piece of new evidence, it's Dr. Iracunda's behavior, which demonstrates her closed mind. The annulment committee in Clockner versus Cameroon explained that an annulment committee can look to a dissent when the impartiality of an arbitrator comes into question. And this goes back to the integrity of the process.
But doesn't the dissent get us into an entirely different issue here? Doesn't this dissent go into the deliberations of the tribunal, which are generally considered to be confidential? How can we consider it? Shouldn't we simply refuse to even look at the dissent in that regard?
There have to be some instances that justify looking at a dissent. Without Mr. Beatrice's dissent, we would not have known of Dr. Iracunda's behavior on the
But what do we really know from Dr. Vietor's dissent? Don't we know that she won, right? He's a little aggrieved. She won. She persuaded the chairman, and so he lost. What does it tell us beyond that?
It shows us that she had a closed mind from her determination for action. She continuously handed out her academic works for others to read, and she refused it.
So we're all going to be disqualified if that's one of the
But there's
standards.
a combination. She also refused to read any of the works that were suggested to her. And so it's this combination of giving without receiving that is the problem, and that demonstrates that she has a closed mind.
Counsel, you say a closed mind. The standard in the convention is ability to exercise independent judgment. Let me ask you a bit about line drawing, because human beings are human beings. There's no perfect objectivity in this life. And if all of us had to live up to the standard of perfect objectivity, we wouldn't have anybody to serve as an arbitrator. How do you draw the line between what might be called normal human predispositions for or against a particular side and what I guess you're suggesting is a pathological type of bias, which means you can't exercise independent judgment?
The situations vary depending on the facts, and these facts demonstrate that she was not able to fully take in the circumstances, the arguments, and the facts presented by the other party.
Not fully, but is anyone able fully to take in all circumstances?
Even if it isn't fully, she wasn't able to do it. She wasn't. The evidence demonstrates that she wasn't able to. She wasn't prepared to see things from a different point of view. She did have an idea on investment, yes, and everybody has ideas. But as an arbitrator, you are put in a position where you have to be able to separate your ideas from the facts and circumstances surrounding the case. The claim was convinced that she was not able to do this.
But counsel, I don't want to trespass into what I think your colleague is going to tell us about, but certainly there are two fairly strong lines of thought about the definition of investment. She falls within one of them. It's hard to say that she's an outlier or that she's in any way unusual about having some views about what should be the definition of investment under the convention.
Yes, we agree that she does have a view, and I've already mentioned that this view impedes her from looking at the facts. But we know, furthermore, we know that what Mr. Vietor wrote in his report has some truth behind it, because the exact passage from Dr. Kuhn's book, Rethinking Arbitration, is found within the award as well.
But she persuaded, she couldn't write that award herself, right? I mean, the chairman either wrote it or agreed with her. I mean, maybe one hopes they didn't pay them too much if they just copied what she'd already written. But after all, they're entitled to do that. They cited her. It's reasonably clear it's from her. Is that problematic?
What's problematic is her behavior, and that is what claimant submits. It is that she gave out these writings without opening her mind to writings in return.
How do you know that she didn't have an open mind when she gave out her writings?
Well, from Mr. Vietor's dissent, we know that she refused to read any of the writings because he suggested to her.
So it's not giving out her writings which shows that she doesn't have an open mind. It's is that push? If I could push you a bit more on that, people give out their writings all the time. How does that show that their minds are closed?
It's not simply the giving out her writings. It's the combination of the two. It's the giving out her writings while at the same time refusing to read anything else. Anyone who reads an article or a document for the second time, especially if confronted with new facts and circumstances, will take different things from it. And so that is why claimant submits that this demonstrates that she had a closed mind.
But she had already read. It's not as if she wasn't familiar with those writings. The dissent suggests what she said was not, I refuse to read those articles. It was, I've already read those articles. I needn't reread them.
Yes, that is true. It wasn't that she had never read it, but again, as an arbitrator, you are there to be impartial and take all of the facts and circumstances, and you said that she was not able to do this. And if this committee will allow me, I'll move on to my second condition, which is that the tribunal did seriously depart from two rules of fundamental procedure, that of party autonomy and equality of presenting ministers. departed from the fundamental rule of party autonomy because both parties have agreed to be governed by the Bellarano model rules. And Rule 5.5 provides that the tribunal shall disregard any expert report by the party appointed expert who fails without a valid reason to appear for testimony unless in exceptional circumstances the arbitral tribunal decides otherwise. This rule clearly sets out that the starting point is to reject the expert report if he is unable to appear. However, and especially if he does not have a valid reason to appear, and past exit cases tend to disregard expert reports when the reason for the expert's absence is within his control. One such example is in Enron, where one witness could not appear because of an injunction that was issued by the Argentinian government. And in the same case, another witness expert was rejected because the reasons he gave for not being able to appear were not valid. In the present case, Dr. Ranipier chose on the very morning of the hearing not to appear. And the reason that they gave was because of wilderness. This shows, this is a reason, completely within the expert's control. This annulment committee should also decide that the tribunal departed from the fundamental rule of equality of presenting one's case. The annulment committee in Krakow.
But didn't the claimants apparently choose not to put in a competing expert report? I mean, that was their choice. They could have done it. They didn't do it. Why is that a departure from, why is their decision not to fully present their case a problem for this ad hoc committee?
It was on the very morning of the hearing that Dr. Ranipier chose not to appear. And the promptest and sufficient way for claimant to react was to ask for the report to be rejected.
But why didn't they ask for a competing claimant, competing expert report beforehand?
Let me pose the chairman's question in a slightly different way. If one side does not put in a competing expert report, should that imply that they accept what the other side's expert says?
No, it shouldn't imply. And in these circumstances, there were only two other experts in the entire world with this type of detailed knowledge. And it was a strong burden to put on claimants to go and find these two other expert witnesses, especially when we only knew on the morning of the hearing that Dr. Ranipier would not be able to appear. And furthermore, claimant wanted to cross-examine that witness, and they wanted to cross-examine him because he's a professor at the state-run university. And also, they wanted to question him to see his credibility and his methodology.
But you didn't just learn on the morning of the hearing that he was going to be an expert, that he had put in an expert report on a particular issue. You knew that months in advance, if not years, and you could have gotten a competing expert on the same issues, even if there were only two others. Is that wrong? Am I missing something?
It is not wrong. However, we did not know that the award would be based on this expert report. And I see that I've run out of time. Thank you very much.
Could I ask one further question, if with the indulgence of the chair? Do I understand then that it is not your case that the fundamental rule of procedure that was involved here is the failure to have an opportunity to cross-examine the witness? Is it not your case?
It's the failure of the right to be heard, yes.
But now I'm specifically asking about the right to cross-examine. It is not your case that that is the fundamental rule on which you rely.
No, it is not. It is the right to be heard because the respondent was able to submit a piece of report which the claimant was not allowed to respond to. Thank you.
Thank you, counsel.
Good afternoon, Madam President, members of the Annulment Committee. My name is David Wall, and for the next 18 minutes, I will make claimant submissions regarding issues 2, 3, and 4. I will first demonstrate that this Annulment Committee should annul the award because the tribunal manifestly exceeded its powers and declined jurisdiction. I will further demonstrate that in making this determination, this Annulment Committee should exercise its power to qualify the contract as an investment. Now, Article 52, 1B of the Basic Convention provides that an award may be annulled when there is a manifest excess of power. So first, what is an excess of power? Well, the commentary and ancient jurisprudence is generally in agreement that there are three circumstances that can lead to an excess of power. The first is where a tribunal exercises power that it does not have. The second, when a tribunal fails to exercise a jurisdiction that it does in fact possess. And the third, when a tribunal fails to apply the proper law. Now, in assessing in this case whether the tribunal exceeded its powers, the standard that this annulment committee should apply is the standard contained in Article 52, 1B, that of manifest. Now, the term manifest has not been explicitly defined in the Convention, but there are a number of annulment committees that have elaborated on what that term means. The annulment committee in Papua versus the Philippines, for example, held that manifest means demonstrable, substantial, and not doubtful. The annulment committee in Slovakia versus United Arab Emirates held that manifest means substantially serious and textually obvious. The annulment committee in Papua held that the term manifest must mean more than simply obvious or evident. Because if that were the case, then the exclusive control over the integrity of the arbitral process, as provided by Article 52.1, could be satisfied by a merely superficial inquiry. And this would not be a standard or an interpretation of that standard that balances the competing goals of finality mix of decisions with the importance of protecting the integrity of the arbitral process.
Counsel, are you suggesting that the test for manifest excess of authority is satisfied even if it's necessary to do a certain amount of detective work? In other words, if the excess of authority becomes evident only after substantial research, substantial thinking, it's still manifest?
Yes, it certainly can be, Mr. Arbitrator. And in fact, the annulment committee in Papua held that as well, that just because something is a difficult question that requires substantial submissions by both parties is not determinative of whether something is manifest.
When would something then not be manifest? If you go through a long period of detective work, thought, and you finally find that there's an excess of jurisdiction, you say it's manifest. When might something then not be manifest?
But as we submitted, first of all, something has to have a serious consequence or a substantial effect on the proceedings for it as one element of it being manifest.
But are you suggesting that any decision to deny jurisdiction is manifest? Because obviously there's a clear result, a clear, strong effect, substantial effect on the rights of the claimant.
The claimant would not go so far as to submit that every single error of jurisdiction constitutes a manifest excess of power, but rather that in many circumstances, a failure to exercise jurisdiction where it is in fact the best will constitute an excess of powers that is manifest, but not certainly in every single circumstance. Rather, what this annulment committee should do is look and see if there is an excess of powers that has a serious impact on the proceedings and is not the product of elaborate interpretations. And this is the standard that claimant submits.
What do you mean not the product of elaborate interpretations?
If the excess of powers is not something that this annulment committee can find without jumping through very, very complicated legal gymnastics, that should not be found to be manifest. Counsel, the claimant is not submitting that any possible error is automatically manifest just because it has a serious impact. We do understand that part of the meaning of manifest is something that must be to some degree textually obvious to the committee.
Well, let's get down to the specifics of what it is that you say is manifest about the failure to exercise jurisdiction here. We're talking about the interpretation by the tribunal of the term investment in Article 25 of the Convention, correct?
Yes, sir.
And am I correct that the case law out there has gone both ways on interpreting that term?
Not exactly as this tribunal interpreted the term. There is case law that includes a requirement of some contribution to the capital, to the development of the host state as one of the characteristics of investment. And there is case law that says that that is not at all required, but rather that a contribution to the development of the host state is subsumed within the investment characteristics of contribution, duration, and risk. But what is different about this tribunal is that they set up a requirement of a contribution to the development of the host state as a standalone jurisdictional requirement. And that is quite separate from the line of ICSID jurisprudence that has included as one of the characteristics contribution to the development of the host state. Now, even Professor Schroyer, who has stated that none of these characteristics of investment should be considered jurisdictional requirements, but rather they should be interpreted as the tribunals in Phoenix Action versus the Czech Republic, in Mondale versus Egypt stated, in the totality of the circumstances of the case. And in fact,
But if we're starting to look at totality of circumstances, aren't we just revisiting the merits of the decision in a way that isn't particularly manifest as far as the outcome is concerned?
What we're submitting is that the tribunal should look to all of these characteristics in the totality of the circumstances, and setting up one of them as a standalone jurisdictional requirement is an excess of powers that is manifest. I apologize if I was making it sound like this annulment committee was the one that was to do that. But it is the tribunal that is to assess that and did not assess that in accordance with either the stream of case law that suggests that a contribution is one of the characteristics, or the stream of case law that says that it is subsumed within a contribution, duration, and risk definition of investment.
Are we limited to 2 lines of case law? Couldn't we have 3, 4, 6, 8 lines of case law in ICSID cases, in investment cases, if we wanted to?
We certainly could have, but unfortunately for respondent, we don't have that.
To follow up on the President's question, is this an area where you think reasonable people might differ? Or are you saying that one position just can't be considered reasonable, the position that was taken by the tribunal?
In regards to the definition of investment?
Yes. It does sound to me a little bit, and I could be wrong, that you're pushing the word manifest almost to the point where it means completely unreasonable. If different people have different views on a subject, then why is one or the other of those views a manifest excess of authority?
What claimant is submitting is that this is not an issue, this is not an issue where this tribunal decided in line with a stream of case law. This tribunal set up the requirement of contribution to the development of the host state as a standalone jurisdictional requirement.
But as a stream of case law is not the same thing as reasonableness. I think you've agreed that arbitral tribunals deciding these investor-state cases are not bound by any principle of precedent. Isn't that correct?
Certainly that's true, Mr. Arbitrator. And the problem is that there is importance, even though there is no stare decisis precedent in ICSID arbitration, it's important that decisions are to some degree harmonious, and that there is there's consistency to the body of ICSID case law.
Who says that? I mean, I suspect that people think that the case law should be harmonious if it's harmonious in a way they agree with it, and that it shouldn't be harmonious if it doesn't, if the harmony disagrees with what they would like the cases to say. So I'm assuming that if all of the case law were, let us say, pro-Cellini, pro-development, you would be encouraging us not to think about the harmoniousness of the case law, but to think that maybe all of those decisions were wrong.
Well, we're not submitting that this annulment committee should either simply go along with what all previous tribunals have said, or simply reject whatever all previous tribunals have there's in fact two manifest errors that this tribunal made. The first one being the failure to consider the bilateral investment treaty at all. And the annulment committee in Malaysian Historical Salvers held that given the importance of consent in the ICSID Convention, and as we know, mere ratification of the ICSID Convention is not sufficient, there must be explicit consent given for claimant and respondent to access the center's jurisdiction by the parties of Ballarat and Australia.
But counsel, you seem to be saying, and you used the word error just a moment ago, you seem to be saying that if the tribunal makes a mistake, that's an excess of authority. Why is a mistake in itself going to constitute an excess of authority?
Not every mistake in itself is going to constitute an excess of authority. But this annulment committee has the grounds, has the power under the ground of Article 52(1)(b to annul the award if there is a manifest excess of power. Now, naturally, if there is an excess of power, the tribunal at some point made a mistake that led to that excess of power. So in this case, a mistake that is manifest in regards to jurisdiction and resulting in excess of power.
What sort of deference should we give to the tribunal's decision itself on jurisdiction?
Well, there should certainly be some deference to the decision. That's why the standard in Article 52(1)(b) is manifest. Not just any error can lead to an annulment of the award.
So in other words, we don't have the power of de novo review over the jurisdictional decision.
This annulment committee does not have, strictly speaking, de novo powers of that jurisdiction. However, this annulment committee must assess whether the tribunal in this case failed to exercise the jurisdiction that it possessed. And in doing so, it's necessary for this annulment committee to consider the facts and the law of this case to a certain degree in order to determine whether the tribunal in fact failed to exercise the jurisdiction that it possessed. And for that reason, plaintiff submits that this annulment committee should look to this case and consider whether the contract qualifies as an investment within the meaning of a contribution, duration, and risk, which are the elements that are or the characteristics of investment which are consistent across its jurisprudence, as well as those that are confirmed by the Bilateral Convention, which we know from the drafting states that a number of definitions of investment were put forward, but were ultimately rejected on the grounds that a definition would create jurisdictional difficulty. And in fact, Mr. Aaron Broch held that the precise limits of the center's jurisdiction were best left to the parties.
Is it your position then that the parties could make anything an investment if they wanted to? That two parties to an agreement could make anything an investment for purposes of ICSID arbitration?
No, Madam President. That would be an interpretation that leaves no room for any meaning of words. We make words empty vessels entirely. But as the annulment committee in Malaysian Historical Salvers held, the Chavo indicate that the only outer limit in the convention to the term provided by the term investment is that the term investment excludes a simple sale or like transient commercial transactions. So it's not that the parties have the power to define absolutely anything as an investment, but the exercise of their discretion to define investment in Article 1 of the Bilateral Investment Treaty in this case, with three requirements: that of a contribution of capital or other resources, the expectation of gain or profit, and the assumption of risk, was a valid exercise of that discretion, their ability to define the investment within the confines of the ICSID Convention.
But doesn't the scheme require that, if you will, we look through both keyholes, that we look through not only the keyhole of the Bilateral Investment Treaty, but also the keyhole of the ICSID Convention? That should be your point, isn't it? And that the ICSID Convention is independent of what the parties have defined. Or maybe I misunderstood what you're saying.
No, I think you understood, Mr. Arbitrator. Yes, it is important to look to both the convention and to the bid. But as I And in this case, we know that the tribunal did not analyze the definition of the bit whatsoever. And as I mentioned before, that the Annulment Committee in Wage and Historical Salvage found that to be, in and of itself, a fundamental error that amounted to a manifest excess of power.
But your argument is that the excess of power occurs under the ICSID Convention. Is that correct? Not the bit. As I said, there would be two different problems here. One is that there's no jurisdiction under the bit, and the other is that there's no jurisdiction under the ICSID Convention. My understanding, but correct me if I'm wrong, is that you're arguing there was no jurisdiction under the ICSID Convention, which is a standalone standard independent of the bit.
Yes, although just to clarify what we were arguing on that is that there are two manifest excess of powers here. One was a failure to consider the bit at all, and the other was requiring a contribution to the development of the host state as a standalone jurisdictional requirement when that is not required by the ICSID Convention. Both of those decisions amounted to a manifest excess of power. And I see that my time is drawing low, so in conclusion, members of the Annulment Committee, in this case there was a miscarriage of justice that severely prejudiced my client. But in fact, this case is about something bigger than just our client. This case is about ensuring that individual tribunals do not raise artificial barriers to the center's jurisdiction that could defeat the very purpose of the ICSID Convention. There is a manifest excess of powers in this case, and consequently, the award should be annulled. These are claimant submissions.
If I could ask just one more question. You haven't gotten an opportunity really to address the facts of this case and whether there was, in fact, a contribution to the economic development of the country. And let me ask you, at what point in time do you measure whether there has been a contribution or not? Is it at the point of making the contract, or is it at the point that the contract itself is rescinded by the government? Was there, in fact, any contribution?
Well, the Annulment Committee must consider all the circumstances of the case. It would not be fair to say you should only look at the actual result, because the actual result could be prevented by one of the parties, like in this case when the contract was canceled. However, I would not submit either that the only place to look is the initial time of the contract, because there could be unguarded optimism about the effects of the contract that simply would never materialize. So it's important to consider the totality of the circumstances in the case. But in this particular situation, the claimant would have completed its contract and was prevented from doing so solely by respondent's actions in this case, by canceling the contract.
But my question was, assuming that you had completed the contract, would there have been any contribution even under the contract?
The only reason why Colorado was able to secure the 2008 gas ban was because of the contract with our client to remove the poisonous Serino-Canto from the island. So the very purpose of this contract was to contribute to the development of the host state, was to remove an obstacle to respondent's development. That obstacle being the poisonous Serino-Canto. And because of this contract, and because of the gas event which followed, respondent was able to showcase its natural beauty in the television coverage of the event, which has led to a significant boom in tourism in Respondent, so much so that it's been labeled an ecological tourism hotspot.
But counsel, couldn't one use that line of argument to justify as an investment a simple sale? Maybe certain events of economic development require the host country to buy products from abroad, and without those products from abroad, the country couldn't develop. You wouldn't go so far as to say that the sale, though, is the same as an investment.
No, Mr. Arbitrator, because as I submitted earlier, the requirements for investment should be defined as having the characteristics of contribution, duration, and risk. And so, particularly the risk element differentiates, in most circumstances, a simple commercial sale from something that constitutes an investment. And in this case, there was a significant degree of risk because it was a bounty contract with a completely inflexible deadline. And the stipulation of the contract that if it was not performed properly by the deadline, all payments under the contract would have to be returned to government does not have. And so, for those reasons, there's a distinct difference between something like what you're submitting and the facts of our case.
Thank you.
Thank you, counsel. Respondents, when you're ready.
Thank you. Good afternoon, Madam President, members of the committee. My name is Lawrence Hainsworth. This is my co-counsel, Marcel Bierwinger. Just to give you the structure that we shall be using today, I shall be spending the next 20 minutes to establish that the award should not be annulled because there has not been a manifest excess of powers. And then my co-counsel shall then proceed to submit that the award should not be annulled because the tribunal was properly constituted. And finally, that the award should not be annulled because the tribunal did not seriously depart from a fundamental rule of procedure. And the respondent reserves 1 minute for a serve rebuttal. Before I move on to our submissions, I'd just like to state that it seems the applicant has brought issues regarding the tribunal's use of its discretion. Its use of discretion regarding what constitutes an investment, its use of discretion regarding the challenge to Dr. Lukwinder, and its use of discretion regarding the submission of Dr. Anikor's expert report. I shall now go on to the first submission. For the manifest excess of powers, I shall be addressing issues 3, 2, and 4, which are found on page 4 of the record in that order. Firstly, the respondent is aware that the applicant has not addressed in any great detail issue 3. So I'd just like to clarify that this is an annulment committee and not a court of appeal. In other words, this committee should restrict itself only to assessing the procedural conduct of the tribunal in ascertaining whether or not there has been a manifest excess of powers. However, it may not go into the merits and to look at the legal reasoning in determining whether or not this award should be annulled. The whole concept behind...
Counsel, when you say we cannot look at the legal reasoning, what if the legal reasoning appears to us to be simply a fiction, that the tribunal didn't examine seriously the questions? At some point, there has to be a substance to the legal reasoning, doesn't there?
The role of annulment committees is to safeguard the integrity, not the outcome of the proceedings. And in other words, as a result, they must restrict themselves to the procedural matters at hand.
So are you saying that as long as the tribunal addressed an issue, we cannot question that decision? We just look to see whether they said, we're going to look at this question and then we move on?
The respondent is submitting, yes, that this annulment committee cannot go into the merits of the case. The applicant has mentioned 2 reasons why the tribunal has manifestly exceeded its powers. Firstly, they stated that the tribunal failed to consider the BIT at all. And secondly, they have stated that the tribunal has made the contribution to economic development of the state a standalone jurisdictional requirement. And I shall address these issues in this order. Firstly, it seems that the applicant is happy to accept that finding whether or not an investment exists, that the double keyhole approach should be adopted. In other words, to unlock the proverbial doors of the ICSID system, the investor must establish that the transaction in question satisfies the requirements of an investment under the ICSID Convention and the relevant provisions of the agreement between the parties.
Let me ask you about that. What are the standards under the ICSID Convention for an investment, and where do we find those?
There is no definition under Article 25 of what constitutes an investment. The respondent is aware of that.
Is there anything in Article 25 of the ICSID Convention at all that gives us any standards for the term investment?
It does not give any standards as such. What Article 25 offers are jurisdictional requirements for there to be jurisdiction. There must be consent between the parties, and there needs to be a legal dispute arising directly out of an investment.
Okay, and where do we find the consent in this case?
The consent in this particular case can be found in Article 25 of the BIT between the parties.
But we find consent in the bilateral investment treaty to this specific case, right?
That's correct. However, the requirements of consent and investment are not synonymous. They are separate issues. For instance, in the institution rules of the exit, Rule 21C talks about this, the importance of parties giving their consent. But then Rule 21E also reiterates this fact that there must be a legal dispute arising directly out of an investment. In other words, by separating out these two requirements in this way, it is clear that these are two separate requirements. And Troyer, in his commentary, has stated as such.
But here we have the parties agreeing to a definition of investment. In fact, I'd like to take you to that if I could. It's in the award, and the bid expressly defines investment as having three characteristics: the commitment of capital, the expectation of gain or profit, or the assumption of risk. Now, those are three of the four categories set out in Cellini. So didn't the parties to this particular bid reject that fourth category of contribution to economic development? And if they rejected it, how can the tribunal resurrect it and make it a requirement of the ICSID Convention when it's not in the ICSID Convention?
The first point that I'd like to make regarding that is that under the double keyhole approach, there are two separate tests under Article 25 of the ICSID Convention and the BIT. Now, regarding the BIT in this particular issue, it is true that it is given three characteristics. However, it is also stated including such characteristics, which means that these three are mere examples. They are not exhaustive. By virtue of Article 31 of the Vienna Convention of the Law of Treaties, we can also interpret this as regarding the context that it finds itself in. In other words, we can look at other treaties that may help with this. And the ICSID Convention...
But we're looking at this treaty between these two parties, and they have the right of sovereigns to conclude the treaty that they want. They didn't conclude another treaty. And isn't it going rather too far to say that the content of every other investment treaty has something to say about this investment treaty? You might just as reasonably say they rejected those other treaties and they chose to do this in their treaty.
The reason why the ICSID Convention may be applied to help with the interpretation of this is because the two states that have signed the BIT, the Republic of Ascania and Vanuatu and Sularu, have also ratified the ICSID Convention. And as a result, it suggests that they have, by ratifying the ICSID Convention, also accepted its application.
But doesn't this argument work the other way as well? I mean, if I'm inclined to accept that there are two keyholes, I don't necessarily see them as running in parallel. I might see them as running perpendicular, and to say that the ICSID keyhole might or might not be narrower than the BIT keyhole, but if you can get in through the BIT, you might often be able to get in through the ICSID Convention.
Well, this test is cumulative, as has been held in Patrick Mitchell and Congo.
And why would we give credence to the Patrick Mitchell versus Congo award, which I think it's fair to say is one of the most highly criticized awards in ICSID history?
That is true. And the respondents are aware, as has been pointed out by the applicant, that there's no precedent in international arbitration. However, by virtue of Article 38.1 of the ICJ statute, subsection D in particular, decisions in the award tribunals may be used to help with this issue.
Right. Well, what does the Article 38D say, actually? I mean, isn't it a source? Doesn't it describe the decisions of case law, arbitral tribunals as subsidiary sources of international law, not as creators of international law? So the suggestion is that one can look to the decision as one hopes doing the work of defining what the general principles are or what customary international law is, but not as making law itself.
That is true. And the respondent is not submitting that judicial decision should be used to create law, only that it may aid this committee and also help the tribunal's considerations. However, in ADC and Hungary, they have also stated, and I quote, that cautious reliance on certainty developed in a number of those cases as persuasive authority may advance the body of law, which in turn may serve predictability in the interest of both investors and host states.
Counsel, I mean, you appear to want us to give credence to Mitchell versus Congo, ADC versus Hungary, and presumably the so-called Cellini line of cases, but we have a competing line of cases. So even if we were inclined to give preference to these earlier decisions, why would we choose some over others? Don't we have to make some kind of independent decision about which are persuasive and which are not persuasive? And you know, you have the ones you prefer, claimants have the ones they prefer. Why should we go either way?
Well, this is, of course, goes to the discretion that a tribunal and this committee has. And in the respondent is aware that there are two lines of arguments. However, in choosing one, that is in itself a new sort of discretion. There are numerous cases on both sides, and both sides of arguments have been criticised for numerous reasons. However, as I mentioned at the beginning, this annulment committee is does not have the power to decide whether it prefers one interpretation over another. It merely can look at the procedural conduct of the tribunal in ascertaining whether or not there has been a manifest excess of power.
Let me ask about that. I assume you would agree that legal certainty and legal predictability is a good value that the system should endeavor to achieve. You would agree with that, wouldn't you?
I would, yes.
Okay. And isn't it our obligation as a committee to seek to develop a jurisprudence constant by following decisions like Malaysian Salvors and find that that there is an investment here?
Well, again, this goes back to what I mentioned earlier, that there is a difference between the notions of appeal, which is expressly rejected in Article 53 of the ICSID Convention, and annulment. Appeal is concerned with the legitimacy of the process of the decision and with substantive corrections. Annulment, on the other hand, is only concerned with the legitimacy of the process of decisions.
But if we were to conclude that the investment treaty definition is important, whether or not it's decisive, and we can see from reading the award, from scanning the award without having to really think about it too deeply, that the arbitral tribunal below didn't consider the definition of investment in that award, isn't that enough for us to annul the decision, even if we don't replace the reasoning with our own thoughts?
In the present disputes, the tribunal has not merely applied one without consideration of the other. May I draw this committee's attention to the award on page 14 and 15, specifically from line 659. The tribunal has clearly looked at the Cellini criteria. They have also clearly looked at the annulment committee in MHS and Malaysia. They have also looked at Patrick Mitchell and Congo. In other words, they have looked at some of the leading cases advocating both sides, i.e. the your keyhole approach and the alternative subjective approach. And yet they have used that expression and found that one was more persuasive than the other. This in itself is not a manifest excess of powers.
But, I mean, what if we do look closely at where you're pointing us? It seems to me that there's no real reasoning. There's simply a listing of cases and then a conclusion that they're rejecting Malaysian historical salvors in favor of the other line of cases. There's nothing to say why they decided to do that.
They have not gone into detail, no. However, it's clear that it has been considered and they've used their discretion in coming to a conclusion.
The President's question, though, brings me back to my earlier question to you as to whether or not it's enough for a tribunal just to say we're addressing a question. And you seem to say, yes, that's all that we should be concerned about. And I guess I would wonder whether that's really true. I mean, if a tribunal just says, here's the checklist of things we've looked at, 1, 2, 3, 4, 5, 6, and then doesn't make any attempt at rigorous intellectual reasoning to get to its conclusion, why should we be bound by the checklist? Don't we have an obligation in terms of ensuring the integrity of the process? Don't we have an obligation to see that there was some effort at intellectual rigor?
And if the applicant had requested that this award be annulled for the failure to state reasons, which this would come under, then yes. However, we are here only looking at the annulment ground of manifest excess of powers. And in such circumstances, this does not come within that ambit. Referring back to the applicant's submission that there was no, that the tribunal did not analyse the BIT, I'd like to just draw this committee's attention to CSOB and Slovakia, which at paragraph 68 stated, and I quote, "A twofold test must therefore be applied in determining whether this tribunal has the competence to consider the merits of the claim, whether the dispute arises out of an investment within the meaning of the convention, and, if so, whether the dispute relates to an investment as defined by the parties' consent to the ICSID arbitration in their reference to the BIT and the pertinent definitions contained in Article 1 of the BIT." Unquote. Now, the reason I have quoted this is because they have clearly stated, demonstrated that the convention is to be applied first. And then after that, if the Article 25 of the convention is met, then the tribunal may go on to look at the relevant provisions of the BIT. And in CSOB and Slovakia, they found that the transaction and loan agreement did satisfy Article 25 of the convention, and so went on to find that there was an investment also under BIT. Now, this is different in the present dispute, because the tribunal found that there was not an investment under Article 25 of the ICSID Convention, and thus, for the sake of judicial economy, it was not necessary for them to go into determining whether or not there was an investment under the BIT. The second issue that the applicant has raised is that they have stated that in applying this condition for contribution to economic development, they have made this a standalone jurisdictional requirement, to use the words of my colleague. First of all, on page 14 of the record, at line 653, they have clearly considered FOIA, which was mentioned by my colleague, and they have quite clearly stated that these criteria does not per se preclude the transaction being an ICSID investment. That's at line 654. In other words, there is no indication that they are actually raising this to a jurisdictional requirement.
But at line 655, they say in such a case, an ICSID tribunal has no jurisdiction. How can they not be raising it to a jurisdictional requirement?
The Salini criteria is admittedly a holistic approach. And this paragraph in question clearly shows that the tribunal is aware that it's a holistic approach, and that they are admitting that if one of these conditions is not satisfied, that does not in itself mean per se that there is not an investment. However, in the present dispute, seeing as the first three conditions of the Salini test were only tenuously met, they felt the need to look more into the contribution of the economic development to ascertain whether or not there was an investment. But furthermore, I would like to bring up three reasons why the contribution to economic development is also an important part of the ICSID system and is an important characteristic. Firstly, by virtue of Article 31 of the Vienna Convention of the Law Treaties, one may turn to the context and the object and purpose to look for a definition of an ambiguous term, in this case, investment. Notably,
is investment ambiguous? Can't we find multiple definitions of it? How do you define ambiguity?
Well, in this case, investment does not have a definition under the ICSID Convention, and that in itself would suggest it's ambiguous. And therefore, we can turn to the preamble of the Convention. And notably, the first clause highlights the need for international cooperation for economic development.
What is the whole purpose of the ICSID convention? Is that the only purpose of the ICSID convention?
No, of course
Isn't
not.
it to settle investment disputes?
It is, and it's
To provide a forum to actually hear cases, settle them, do so in a way that does not implicate either espousal and diplomatic protection or gunboat diplomacy?
Of course, and it
So
is.
why shouldn't we give credence to that goal of the ICSID convention?
Madam President, I'm aware that my time is up. But,
No, please go ahead and answer.
the respondent does not have, well, in some instances it accepts that protecting the rights of investors and their investments, as well as the host states of these investments, is an important object and purpose of the ICSID system. However, this first clause may be construed as an objective condition for an investment, and that has been held also in joint mining and Egypt. If I may just briefly mention the other two reasons that I came up that I would like to submit. The link between the World Bank and the ICSID system is inherent, and it demonstrates that there should also be, by virtue of this, the contribution to economic development, as the goals and the aims of the World Bank Group clearly aim to promote economic development to alleviate the greater problem of poverty. And as being part of this institution, ICSID should also promote the same. And thirdly, the ratification of the ICSID Convention brings with it the erosion of state sovereignty. And states are not willing to part with some of their state sovereignty unless they feel that they have assurances that it will bring in contribution to their economic development with the inflow of investment. If, Madam Archer, may I have just 1 minute to also address the issue regarding why there is not contribution to the economic development?
Preferably less than 1 minute.
Okay. Very briefly, the contract is not the investment itself. By virtue of the definition provided by Article 1 of the VIT, it is clear on page 13 of the record that the contract is an investment agreement. The rights conferred by that contract are the investment. In other words, the investment is the authorization to remove the fraud, not the contract itself. And thus there is no causal link between the investment and the economic benefits, because the economic benefits have only stemmed from the contract, i.e. the investment agreement.
Didn't the parties, and with the indulgence of the chair, didn't the parties themselves expressly agree that this contract would promote the economic development of the country?
Well, the respondent submits that no, they have not. The respondent state was hopeful that it would result in obtaining the right to host the gas, and as a result having two as a result of that. However, the applicant only entered the contract because they wished to procure as many faults as possible, which is evident on page 1 of the record. This concludes the response question.
Thank you.
Good afternoon, Madam President, members of the panel. Being aware of the already advanced time, I shall restrict myself to submit in the next 16 minutes that the applicant's second and third submission, namely that the award should be annulled because of the constitution of the tribunal and because of the alleged serious departure of a fundamental rule of procedure, are ill-founded. I will start with the first point, namely that the tribunal was in fact properly constituted and that therefore the award should stand as it is. The applicant has submitted that Professor Irakunda reasonably appeared to be biased and that therefore the award should be annulled. As counsel of the applicant has correctly stated, there is no definition of what constitutes a proper constitution of the tribunal. However, if we look at Chapter 4, Section 2 of the ICSID Convention, there is nothing in the ICSID Convention that would indicate that a failed challenge to an ICSID arbitrator would fall under this ground for annulment. It merely deals with procedural rules such as the number of arbitrators, their nationality, and the time in which a tribunal should be constituted. The same has been held by the annulment committee in Asterix and Argentina, which has stated that that the annulment ground may be justified if a challenge has been made under Article 57 but has never been decided, or if it has been decided by the wrong body according to Article 58. However,
but surely the integrity of the process has to last throughout the entire proceedings. It can't be over as of the time the tribunal starts its proceedings. It has to continue until they finish their proceedings.
that is correct. The respondent merely submits that the grounds that the applicant has invoked partly cover submissions that have already been dealt with by the initial challenge, by the two remaining arbitrators that have considered these objections and rejected them.
But assuming we agree with you, don't we have at least 3 new areas of information that we didn't have before? We have the award itself that suggests perhaps a disproportionate influence from Dr. Irakunda's earlier views. We have the dissenting opinion, and we have the more information about wilderness and its apparent vociferousness in trying to prevent its members from taking part in this procedure. Shouldn't all of those cause us to revisit the decision about Dr. Irakunda?
This will bring me to my next point. I would now address the applicant's submissions regarding Professor Irakunda's membership in the International Charity Wilderness. The applicant has submitted 3 points of why this might be problematic. Firstly, the applicant has submitted that Dr. Ranapur did allegedly not attend the hearing because of the organization. However, this is factually wrong. Dr. Ranapur did not attend the hearing because he was convinced by members. This does, however, not reflect the policy of the entire organization. Secondly, the applicant has relied on the English House of Lords case, Pinochet, and has stated that on the basis of this case, this challenge might be successful. However, it has to be stated that it is a House of Lords case, and that such it is English law and therefore applicable in this case. Secondly, it has to be distinguished on the facts. Lord Hoffman, who was challenged in this decision, was a member of the board of Amnesty International. And Amnesty International had a direct interest in the outcome of that case. Furthermore, Lord Hoffman was fundraising for Amnesty International, and his wife was working for Amnesty International. In this case, Professor Irakunda is merely a member. However, Wilderness is not an interested party in this case, and it is not a party to the dispute, and moreover, it has no interest in the outcome of the case.
What standard should we, I know you're addressing the facts, but what standard should we be using in deciding this particular issue? That is, shouldn't we be using the IBA standard, which is used in the IBA guidelines, which is used in UNCITRAL cases? Why is there any difference or any reason for us not to use those guidelines so that we have a commonality in all investment arbitration?
Well, first of all, the IBA guidelines are not binding on this tribunal, and the parties have not agreed to apply them. Therefore, they may merely provide a persuasive authority. However, the applicant, in submitting the standard of a reasonable person, has relied on the Tribunal Alpha Project Holding. However, the Tribunal Alpha Project Holding has submitted that the term manifest, according to Article 57, does not imply a reasonable person standard, but that the term manifest should be construed as meaning obvious and evident. Therefore, the standard to be applied here is that manifest must mean whether there is obvious and evident evidence whether an arbitrator lacks impartiality. This evidence must be objective, and a mere inference is not enough.
Don't we have that in the dissenting opinion?
The dissenting opinion merely reflects the subjective opinion of Dr. Ranapur. Furthermore, the dissenting opinion is factually incorrect, because Dr. Ranapur states that, Dr. Vieita states that Professor Irakunda refused to consider different texts, but the dissenting opinion also states that she does so because she has already read them. And since she has written a book, Rethinking Exit Arbitration, there is no doubt, there is no reason to doubt her statement that she has in fact read and considered them. And as my co-counsel has already pointed out, the award itself states the case in MHS Malaysia, which advocates the opinion submitted by the applicant. And this case has been considered and rejected. Therefore, it cannot be said that Professor Akunda refused to consider other opinions. Furthermore, the applicant regarding Professor Akunda's membership in Wilderness has also relied on her financial donations. However, there is no rules in the ICSID Convention that would prevent an arbitrator from donating money to an NGO. In the inverse case, this might indeed be indicative. However, in this case, it cannot be said that she was in any way dependent on Wilderness. Moreover, she merely states that she supports their underlying principles of conservationism. And I do think that most of us will agree that those principles are indeed supportable. Therefore, it is not said that she does agree with all statements and all policies that Wilderness states for or applies in particular.
You just, Counselor, you just said that there's no indication that she was dependent on Wilderness. Why should dependency matter? I mean, that might be something that one takes into account with respect to independence, but one can be impartial or not impartial. The test can be stated either positively or negatively, according to standards that have nothing to do with dependence. I mean, you can basically prejudge a case even if you're not dependent on a particular organization.
This is absolutely correct. However, the fact that she has donated money to Wilderness does not state that she is impartial because of her membership. The only reason why financial ties might be relevant is if an arbitrator is dependent of a party to the dispute. But here there is no dependence whatsoever, and neither is she partial merely because she is donating money. As stated, the fact that she donates money merely implies that she supports, as she states herself in her statement, that she supports the underlying principles. That does not mean that she supports every policy of Wilderness. And I would like to add one more.
I just want to, does it matter at all how much money she contributes? Is there, in your view, any relevance to the fact that it was a small amount of money as opposed to a large amount of money?
I would first like to point out that there is no facts on the record of how much money she does in fact donate. Respondent concedes that a significant amount of money might amount to an appearance of bias. However, first, she only donates, as said, there is no facts of how much money she does spend. And secondly, an appearance of bias is not enough on the standard that was proposed by the respondent. I would now like to address the second issue that was submitted by the applicant, namely that the tribunal allegedly departed from a fundamental rule of procedure. The respondent submits that this is not the case and that therefore the award should stand. First of all, Article 5.5 implies two caveats to the rule that an expert report should not be admitted if the expert does not attend the hearing. These two caveats are, first, if there is a valid reason, and second, if there are exceptional circumstances. In this case, both these caveats are present because, first of all, there is a valid reason for Dr. Ranapur not to attend the hearing. The applicant has stated that this valid reason is because of Wilderness, but again, this is factually incorrect. It is not because of Wilderness, but because Dr. Ranapur is of the opinion that an attendance would imply his support of the treatment of the Syrian acanthophoros frogs by the applicant.
But how can that be a valid reason? And if it is a valid reason, shouldn't he have to withdraw his expert report?
First of all, the respondent admits that this is a valid reason because for him it is a matter of conscience. As a matter of conscience,
his conscience is awfully convenient. It appears he prepared an expert report, presumably got paid for it, and now suddenly had an attack of conscience that doesn't let him appear.
Well,
He knew about the frogs before, that was public record. Why is he now permitted to abide by his conscience?
Well, first of all, he was convinced by other members of the wilderness that this would imply his support. And matters of conscience are not always easily perceivable at the very first moment. So it is, there's no reason to doubt that now, since he talked about it, or since he gave it more thought, that this would now lead to his opinion that a further attendance of this proceeding would amount to unconscionable behavior. Second, if I may refer the panel to Rule 35 of the arbitration rules, according to Rule 35.3, each expert is required to state that he solemnly declares upon his honor and conscience that the statement will be in accordance with belief. And since this was a matter of conscience, and since he believed that any further support of this proceeding would violate his conscience, he showed more integrity than any speculative.
Well, assuming that everything you've just said is correct and that he's a man of great integrity and he had an attack of conscience and such, why should that be allowed to prejudice the applicant, though, so that they don't have the opportunity to confront him, to cross-examine him, to bring out further evidence, or to determine through him the credibility of his report?
This would bring me to the second point that has already been raised by the applicant, namely that the applicant's right to be heard has been violated. The respondent admits that this is not the case because, first of all, the applicant had ample opportunity to review the witness report. It was submitted before the hearing, and therefore they could have a look at it. Second, the applicant has stated that the reason why they did want to cross-examine Dr. Rangapur was to look at the methodology of his statement.
Right, and to undermine the credibility of the report. And they thought, reasonably enough, because of the agreed-upon procedure, that that would occur at the hearing, and then that opportunity was taken away from them.
That is correct. However, the report itself contained a section about the methodology. Therefore, it would have been easy to contradict the report on the basis of this methodology, or to submit questions, or to submit a different expert report that would raise doubts as to this methodology.
But there are different ways that it's absolutely true that claimants could have done different things, and they chose to do one thing that could have undermined the credibility of the report, and now that's been taken away from them. They shouldn't, I think, have to anticipate every eventuality, every attack of conscience by an expert and put in 3 times as much evidence as they might otherwise need.
Indeed, that is true. However, the applicant has the burden of proof to show that the investment did in fact contribute to the economic development. Therefore, they could have submitted evidence before it. They knew that this point would be of importance in the proceeding. In the Atonement Commission Klöckner 1, the ad hoc committee has rejected claimant's claim on exactly this ground. They stated that if the applicant has every opportunity to express itself and present its case, then there is no undue process, and therefore the applicant's right to be heard is not violated.
Counselor, are you suggesting that a party is deemed to accept a report of the other side if it does not give its own report?
Excuse me, could you repeat?
Are you suggesting that the fact that one side does not give a counter-expert report means that it accepts the report of the other side? Is that what you're suggesting?
No, I'm sorry if I have not made myself clear. This is not what the respondent is suggesting. The respondent merely suggests that the applicant could indeed have submitted their own evidence.
But they didn't. They decided to take another route to challenging the views of their adversaries, and then that other route was taken away from them.
But it is exactly that route that is now contested by the respondent. The applicant knew that there was this expert report, and they requested that the expert report shall not be regarded. However, after the decision by the tribunal has been taken to admit the expert report, the applicant has not filed any further objections. Therefore, they have waited until the tribunal has issued their award, and only then have they claimed that there was a departure from a fundamental rule of procedure.
But that seems to be a suggestion that once one side has filed a report, the other side has the duty to file a counter report. But you're not saying that.
No, Mr. Arbitrator, this is not what the respondent says. The respondent admits that if the applicant deemed that there was a departure from a procedural rule, they should have stated so before the award was filed. This is expressly stated in Rule 27 of the arbitration rules that objections to violations of procedural rules shall be raised promptly.
But they did object to the report, and they asked that the report be struck from the record, right?
Which is the presumption in Article 5.5 of the rules.
The applicant only requested that the report be disregarded, but it did not object to the actual decision of the tribunal. Therefore, it has not objected to the procedural violation when it occurred.
So you're making the very technical argument that moving to strike it itself was not sufficient because of the rule, and that they actually had to come back after the decision was made and object again?
This is correct.
I'm a little concerned about something you said about the effect of the witness statement. It seems to me that Dr. Ranapur is an expert on frogs. He's not an expert on economic development. So I believe you said that his conclusion was that the removal of the frogs by Max Solutions was not a contribution to the economic development of the state, whereas in fact I believe the only thing that he said in his witness report was that the frogs would have died, or many of the frogs would have died even without Max Solutions' intervention. So I'm not sure, and that seems, so it seems to me his expertise is limited. He's not an economist, he's not an investment specialist, so it's not so clear that claimants even should have relied or should have recognized the purpose for which the tribunal would rely on this report.
Dr. Ranapur's report it is a common fact that the frogs were struck by the disease, and it was also known that they would die. Dr. Ranapur's report dealt with the likely impact. That means that the time frame in which the frogs were likely to die. This would conclude the respondent submissions if there are no further questions.
No? Thank you.
Madam President, members of the Audit Committee, counsel respondent has stated that the tribunal did not raise the requirement of a contribution to the development of the host state at a level of jurisdictional condition. So that is simply not supported by the record. On pages 14 and 15 and 16 of the record, the tribunal assessed the first 4 characteristics in the Salini test and found that all 4 of those were met, but declined jurisdiction after finding that the contribution requirement was not met. They based their decision ultimately solely on that single requirement. By raising this to a level of a jurisdictional requirement, something that is not supported by ICSID jurisprudence, ICSID commentary, or the text of the ICSID convention itself, amounted to a manifest excess of power. Consequently, this annulment committee should annul this award.
Madam President, members of the committee, on page 17 of the award, line 805, they have clearly stated that the other 4 conditions that were looked at were only tenuously met, the particular words they knew of, with the tenuous nature of the satisfaction by the transaction of every other Salini criteria.
Did they explain why it was only tenuous?
In the award, they have gone into each condition with reasons as to why each one was only tenuously met. Yes, they have. And by virtue of this only tenuous meeting of these criteria, because of the object and purpose of the ICSID Convention, it was clear that contribution to economic development needed to be met by more than just a tenuous nature. This concludes the civil part.
All right, thank you, counsel. This will conclude our session. The arbitrators will deliberate and we'll give you our decision shortly. Thank you all for coming.
that everyone stay in the room for years and run for even deliberation.
Fantastic job.
After that, they will come back with some comments to the two respective teams. And then immediately after that, we're going to have a presentation of a number of the awards from the competition. So if you want to, you can just stay here. After we go through the awards.
We're not the ones who are going to announce the winners, but I think I can speak for all three of us in saying that it was an extraordinarily difficult decision. I don't generally have problems making decisions, but I had a lot of problems with this one. I thought the advocacy on both sides was extraordinary, absolutely extraordinary. You see this kind of level of advocacy very rarely in real practice. And in real practice, there are some exceptionally good advocates, but all of you were really outstanding. I think you all have very lucrative and rich careers ahead of you. I think with that, I'll turn it over to Rusty.
The difficulty in judging came from the fact that nobody really made a mistake. Often when one judges this sort of competition, one can make a decision based on the fact that this advocate or that advocate fell down on a certain question, or this advocate or that advocate lost his or her cool. But nobody lost their cool. Nobody made a mistake. All of you were just excellent in getting back with focused comments that were reasonable. It was a superb performance.
I echo everything that my fellow panelists have said. You know, I would say that, you know, you claimants were very wise in the way you outlined your positions and drew your positions and refused to be led astray into taking, some indefensible role. Respondents, you were extremely impressive in the way that you were able to not only make your arguments, but respond to the claimants themselves in the manner in which they had presented their arguments. So we were really very impressed by both teams, and it's a pleasure and an honor to be here. Thank you. And thank you for making our job so difficult.
Now, before we excuse the ad hoc committee who has done a lot of work here, we're going to have to offer a round of applause. Thank you very much. And now we come to a moment where we're going to do something that should be fun. We're going to hand out a lot of awards. And so we're going to start, Chris is going to start, but we have a number of things we'll get through, and it will culminate in the team that wins this Gennox trophy. So we'll take our time, but we have a few things to get through here. So hang in there and we'll start.
The first thing we want to do is catch up a little bit. Last night when we announced the memorial counter number winners, we didn't disclose the real identities. And I want to do that now just briefly so that we know who they really are, and we want to give them all applause. So as I go through it, let me start with the best memorial category. The third place team was from St. Petersburg State University. Please give them a... The second best memorial was from the University of Buenos Aires. And the best memorial was from a team that was absent. That's from Malsar University of India. And with respect to the counter memorials, the third place counter memorial was from the Russian Academy of Justice. The second place counter memorial was from the University of Cologne. And the best counter memorial was also from St. Petersburg State University. Now, with that, we're going to move on over to a special category that we have. We had initially two teams from Africa participating in the competition. One of them submitted memorials but wasn't able to travel here because of visa issue. And I'd like to ask Mr. Joseph Mbaduga, is he here? Oh, there he is. Please come forward. From McCarthy Barbuga Advocates in Lagos, Nigeria. He sponsored a prize for the best applicant team. I'd like him to read out the winner and he can present it. It's a helpful prize to finance the next participation.
Ladies and gentlemen, it's my pleasure to read out the winner of the prize from my cousin Madam, Vice of the Solicitor of the Supreme Court. This is
And now we're going to turn to honorable. We're going to be going through a list of 10 students who, through this competition, qualified as advocates to receive the annual, the Honorable Mention Award. There are 10 students. After that, we will then have a separate award for the best advocate of the competition. In order to help us, though, present the Honorable Mention Awards, I'd like to invite up to the podium. We happen to have with us this year 3 students who won the Best Advocate Award from prior years. So first I have Luja Sharma here, if you could come up. I believe it was in 2008, if I can get it wrong. And then we have Otilia Babiak, who from 2008. And we also have, I hope, is Daniel Barbosa in the room. Daniel, please come on. Now, perhaps I'll ask, how about Otilia, the woman on the 2? You can go ahead and read. These are the 10 honorable mention students who won honorable mention for the best advocate. What we can do is if you can read them through, and then we'll hold our applause at the end. If you hear your name, please come up to the front.
Christina Arcari. We have Matthew Crow from Northumberland University. Joe Parsons from University of Pittsburgh. Matthew Delja from NYU. Annie Lawson from Pepperdine University. Anna Barkova from Charles University. Madhulika Srikumar from Gujarat National Law University. We also have Greg Brown from University of Pittsburgh. We also have Maria Strekalova from St. Petersburg State University. Maciej Gorgon from University. And Jessica Stein. Nope.
Tilia, who's a counsel at the ICC, the International Chamber of Commerce, who will present that award as well, along with a book here. I'll let you do that, Tilia.
Jessica Vanderkamp from University of Hong Kong.
Get you all together for a picture. Just by way of explanation, because it kind of fits into the next category that we're working on now. The advocacy awards are based on the performances in the preliminary rounds, and not just for those who advanced on preliminary rounds. The best two of your performances in the preliminary rounds count to the advocacy results. We're going to post the top 50 on the website in the next few days, and then we'll be sending all of you your certificates with your individual scores in the coming week to 10 days. Okay, so you'll receive lots of details that you may or may not find interesting. The next category has to do with the highest ranked team. That category is a combination of the advocacy scores of the entire team and the memorial scores. Okay, there's theoretically the possibility to have a total of 1,200 points in the preliminary oral rounds, okay, 4 times 300, and the possibility of having up to 600 points on the two memorials. All right, so that's the basis for these awards that we're going to do now. I'd like to ask Taylor Trump is here. Okay, he's not here, we'll just do that. So, for the highest ranked team, could I please have could the Universitas Gajah Mada Praktik Indonesia please come forward? This is the third ranked team. Is anyone here? Well, no, you can't take the The second highest ranked team is the University of Pittsburgh School of Law. Oh, well, we'll get a photo later. Okay, come on, you guys. And the highest ranked team they've sponsored a cash prize of $1,500 as a reward for all your efforts, and I hope you'll spend it wisely. The details about the demon during
Now we're going to go to the overall placement. Now this is based, of course, on everything that's occurred. So we're finally coming to the end of our announcements here. And we're going to start with those teams that were in 5th place and then to 7th place. Then we'll go 3rd to 4th and then finally 2nd to 1st. So bear with us here. And so first of all, those 2 teams that from the consolation round achieved 5th place in this tournament, University of Pittsburgh School of Law and Charles University Faculty of Law. So please come up. And now, at that same round, we had the 2 teams that achieved the 7th place in this, and that would be University of Warsaw School of Law and Suffolk University. Now we will announce the 3rd place team, again from the consolation round that took place earlier this afternoon. So in 3rd place, we have Harvard Law School. And as a result of that same round, in 4th place in this competition, we have New York University School of Law. And now, so we're to the final 2 teams, so you've been sitting up here waiting patiently. In order to award the 2nd place, I'd like to ask Bill Bishop to come up here, and I don't know if Sylvia's in the room. Come on up. With this award, accompanying this award, the team that is in 2nd place, which we'll find out in a moment, also will be receiving, not now, but when it is published, soon to be published, a new book that we have our co-authors here. It's called Annulment Under the Exit System. And the 2 authors here, we're so thankful to have you. And so we'll ask you to announce the award. And
So we get to announce.
You get to do that now.
Okay. All right. Well, it is my great pleasure, and I think our great pleasure, to present the 2nd place to the respondent. You did an absolutely outstanding job.
Williams and now that was King's College London.
And now we'd like to ask Tim Nelson, I'm not going to let you out, but Marco Schnabel from Skadden, our global sponsors who will come up and work with
Before we do that, we have to pay homage, tribute to people up here that will be presenting awards, Chris Gibson, Chris Campbell, Sabrina Manuela, and also, of course, the many arbitrators who have been part of this, and the question writers, the evil geniuses behind the frogs. It's a pleasure to sponsor this, but it's really the association of hardworking people who have put their heart and souls into this competition. Now we're in our 5th successful year. It's been wonderful to meet all of you, and so it's wonderful to be presenting Skadden Trophy to the winning side, whose identities have thus far been kept safely anonymous. The University of Ottawa.
We're also happy to give the winning team the Investment Treaty Arbitration and International Law. 5 volumes. In case you want to read it. And so now with that, I just want to thank all of you for staying with us until the end of a long marathon weekend. I hope you found all of it to be a very rewarding experience. As you know, there's food and drink waiting immediately outside the room, and I think I suggest we go straight there.